Hey folks, Attorney Sharif Silmi, and we are now in the second Trump administration. So I wanted to get online. I'm getting so many emails and questions and phone calls, and folks out there are certainly unsure or feeling the anxiety of change and what that entails for them and their families. So I wanted to hop on and make sure that we are um, informing you all about what is going on and what is to be expected in the coming years ahead. So first of all, there's been a lot of reporting about the new administration's priorities as it relates to immigration, and we're starting to see some of the actions that the Trump administration is going to take as it relates to immigration, and mostly it's impacting the border. An emergency is going to be declared such that the border will be closed even to asylum seekers. So anybody who is outside of the U.S. and in danger and seeking, refuge to the United States would likely have a lot more difficulty than there has been in the past regard to entering the United States in order to seek protection from harm and danger. So the idea that they would be able to seek refuge in the U.S. Is becoming, I think, something that is probably going to be a lot again more difficult or even impossible for the foreseeable future, at least until the supposed emergency subsides. The interesting one I thought was that Trump, and this is one that I think can probably have more direct impact on a lot of our listeners. So those of you, and we haven't seen the details yet, but those of you who are in the United States on temporary worker visas or visitor visas, and if, for example, one has a child who is born in the United States, the Trump administration, through an executive order, is seeking to declare an end to birthright citizenship. Now, I believe this will be challenged successfully in the courts because the 14th Amendment of the United States Constitution does provide that natural born individuals naturally born on U.S. territory are citizens. Therefore, it would an executive order would not be strong enough in a legal sense to override a constitutional guarantee. The Constitution is a much stronger document that would require significant majorities in the House and Senate, and 2/3 of individual state legislatures would have to ratify that change as well, and then it needs to be certified. So I don't think that an executive order, I mean, this is potentially red meat for Trump supporters, but it's not likely that a birthright citizenship would be something that would go away through an executive order. So the president cannot change the Constitution on his own. So we'll see what happens here. We'll see when the details come out. And I would, bet $1 to a donut that this is going to, be challenged in court. We are seeing more things related to the border. For example, involvement of the U.S. military and border security, and declaring, as I said, migrant crossings along the U.S.-Mexico border to be a national emergency, which would allow federal funding to be unlocked in order to be used to fund either border wall construction without approval of Congress or for more strict enforcement activities. Another one was the designation of, drug cartels that are mostly, found in Mexico or south of the Mexico-U.S. border to be terrorist organizations, allowing for more funding toward enforcement mechanisms. So far, these are what we're definitely going to see a lot more border enforcement. That's kind of the political mandate that the Trump administration has. But we're not going to see any executive actions that would curtail one's ability to seek an immigration benefit for those who are lawfully admitted into the United States or seeking to be lawfully admitted into the U.S. Not at this time, at least. What we do know from the latest trends for employment-based self-petition still stems from basically April of 2024, where some of the filing fees changed. For example, the I-140 for both EB-1A and NIW petitions increased, marginally from $700 to $715. And there was the introduction of a new asylum program fee of $300 per application for self-petitioners, and then employers with more than 25 employees would have to pay $600 for the I-140. Now, I imagine that the Trump administration is going to want to reduce or eliminate funding that's available for asylum-related activities. So you might see that go away possibly, or some changes with regard to the asylum program fee. There have been also significant changes in the past, even a week or so, on the O1A visa. So for O1A, there was clarification. Again, this is clarification of existing policy, and that usually happens because of lawsuits that seek to demonstrate that there have been inconsistencies in adjudication. So we have seen that as a issue. So we're going to want to, make sure that we're in a position that takes advantage of it. So many people, for example, might have an EB-1A approved and are waiting in a backlog, because even for those of you from India, there is a couple years backlog for EB-1A. So the clarification that exists for the O1A allows for a individual to be the owner of a company that sponsors his or her own O1A visa. And this would be a really interesting mechanism for individuals who are on an H-1B visa and wanting to have their own company to file for an O1A under your own company, in order that you are, first of all, freeing yourself from the shackles of your employer, and secondly, while maintaining your visa, eligibility, obviously, and legal presence in the United States. And secondly, it's a important first step toward acquiring an EB-1A, because having an approved O1A creates a presumption under the law that you will qualify for EB-1A. So this is a very useful update and step. And again, this is something that just came out a little over a week ago. So I'll try to do a special video on that. I'm just touching on a lot of different things today, just to address a number of questions that are out there. There has been clarification in eligibility criteria for national interest waiver petitions, particularly for those who are in STEM-related professions. So USCIS will now consider whether the occupation in which the petitioner proposes to advance an endeavor, if applicable. So what they'll do is they'll look at whether the 5 years of post-bachelor's experience is in the particular specialty that they're seeking the proposed endeavor in. So that's just a small modification from past policy, and that the exceptional ability that they have would relate directly to the proposed endeavor. So, and this is, obviously not a big change, I think, for those of us who grapple with NIW, because when you're thinking about a national interest waiver case, what you're doing is you're proposing an endeavor that you will do in the future. Now, what USCIS is saying is that either your education your 5 years of experience or your 10 years of experience under the exceptional ability regulatory criteria must be in the same area where your proposed endeavor will be. Great, that's wonderful, because the second part of the Danisar analysis, so after you demonstrate that your proposed endeavor is of national importance or and has substantial merit, the second part of the Danisar analysis is that you're well positioned to advance the proposed endeavor. Guess what the most important way that you demonstrate that you're well positioned to advance your proposed endeavor? It's that you have past success in similar endeavors. So the legal requirement has always been that you have to have past success in similar endeavors as your proposed endeavor. So the fact that they want your experience to be within your proposed endeavor as it relates to the exceptional ability requirements, is par for the course. It's not a big change. And I think that overall, we're not going to see many people impacted by that, so long as they have the right guidance in, preparing and submitting their petition. So, and this is just the implication that they must declare how their, expertise aligns with their proposed endeavor. With regard to premium processing, so premium processing has changed in the past year, and it did go up from, I can't remember how much it used to be. I think it was around $1,440 or so, or $1,500. Now it's $2,805. So since about a year now, premium processing has been $2,805 for I-140s in EB1A and EB2 NIW. This ensures, in the case of an EB1A, that you'll have a decision within 15 business days, and with regard to NIW, within 45 calendar days. My experience has been that the NIW decisions are coming much faster than the 45 calendar days, although that's the standard that exists. And premium processing is beneficial for those who, have time-sensitive plans or impending changes in employment. And, most of the folks who are filing in an EB1A category, generally, I would advise that they do premium processing. There's so much nonsense out there that somehow premium processing will, result in less approval rate than non-premium processing. That is baloney. There's no data to support that finding. Rather, I find that the premium processing adjudicators are very fair. They take a good look at the evidence and, tend to give a decision that makes sense, so long as you're, having a well-prepared case overall. So paying for expedited processing does not influence the substantive decision on the petition, and a well-prepared application remains the essential thing that you need to do in order to have your case approved. So, we've seen like a lot of trends with regard to approval, and within our own data sets, our approval rate is extremely high. We're, in the 95% range in self-petitions. We're really, really proud of that. And I think that, the overall rate is actually much different. If you look at the overall rate for EB1A, for example, it's about 51% approval rating. And with regard to Indian nationals, it is below 40%. Below 40% for Indian nationals. So something is wrong with the approach that many people are taking, particularly following wrong advice that is in the forums, or using the kind of superficial media that's paid media and PR. I mean, adjudicators can see right through that. So that's definitely the case. There are sectors that I find are better than others. So anybody who's in a kind of deep technology area, STEM related activities are always going to be looked upon as more complex and, in need of, greater benefit to the United States. So that kind of industry, like technology, healthcare, scientific related professions, have higher approval rates because they more readily demonstrate the sustained national or international claim requirement for EB1A. And we have seen specific language included in the USCIS adjudication manual, particularly benefiting individuals who are in STEM related areas for EB1A approval. And so applicants should definitely highlight those achievements and demonstrate that there are significant contributions to the field. So I think overall, we're the jury is out. We don't know 100% of what's going to change as it relates to adjudication practice, but I do have serious concerns for folks who are stuck on H-1B in a visa backlog. I think that changing employers, for example, might be more difficult than it has been in the past when you're filing for an H-1B transfer, because an H-1B transfer is not really an H-1B transfer. An H-1B transfer is an H-1B application. You're filing a new I-129 with an H supplement. There's no transfer. There's nothing called an H-1B transfer. It's an application for an H-1B filed by your new employer, and it will be subject to the same kind of requirement that a new application must meet. So, obviously the requirements of an H-1B are pretty clear. And if you had a H-1B approved in the past, you should be fine. But there are lots of issues that come up, whether it's dates or days abroad, or, the title changes, or, duty changes. And we've seen HR departments not really care that much about the plight of an individual's immigration benefits. So the things that happen, I think, in regard to folks on H-1B can be quite severe. So those are things that, we're going to be worried about going into the future, where you have probably a more strict policy as it relates to H-1B. And again, that's why it's important to put your immigration issues behind you and get your hand on that green card. So consider consulting with Silmi Law to navigate the complexities of your overall situation. You don't necessarily need to be like contacting us because you want to file a particular application. A lot of people just want to know, what's the best thing I can do? What plan should I make? Spending a few $100 to figure out your life is probably worth it. So it's important to go on our website, silmilaw.com, schedule a one-on-one consultation. I will make sure that you get value for whatever you spend, I promise you. And also, it's really, really sensitive in terms of, where you are and how you need to get to where you need to go. So we could come up with a lot of innovative solutions, thinking outside the box, coming up with, different, probing your situation and finding a way to figure out what the best course of action is. So I encourage everybody to reach out so we can assess your individual situation in light of these updates, and just seek the guidance that you need. We are going to continuously provide updates, so please subscribe to our channel to understand, leave us questions or comments, and we'll try to get back to you. But the best thing you could do is to visit our website and book a one-on-one consultation with me personally. And I will make sure that, we'll put you in a best position to achieve all of your dreams and to make sure that you're going to be successful in your future. So that's what it's all about. I hope this is a good update for you guys. We're definitely watching very closely what is going to happen. One other quick update actually is that the Trump administration selected James McHenry as the acting attorney general. And again, this highlights, so James McHenry, for those of you who are not familiar, was the individual responsible for the Executive Office of Immigration Review, commonly known as the immigration courts. and he was the person in charge of the judges. And I think that this is an indication that the Trump administration, and he's a hardliner when it comes to, immigration rules and removal. So this is clearly an indication that the priority for the Trump administration is going to be removal of individuals who are, not having, a visa or paperwork to be in the U.S., and those individuals who are on work visas or seeking immigration benefit based on, merit or based on employment. I think that you're probably going to be in the same situation you've always been in, and that hasn't been a great situation. So I don't think that, we're going to be celebrating that, things are going to be a lot better, but I don't imagine that they're going to be dramatically worse, except for the issue of H-1B. We've seen the power struggle within folks who are, in the Trump administration. And we've seen that, Vivek Ramaswamy, who's one of the proponents of H-1B, is going to be leaving the Trump administration to run for governor of Ohio. So I don't know if that was a power move by, the Steve Bannon and, other immigrant hardliners like Steve Miller, or if that was something that, Ramaswamy wanted to do. And it's still going to be important to see what happens. I mean, we did see a lot of the tech CEOs at the inauguration. Obviously, Elon Musk was there, the CEO of Google, Tim Cook, and others, Zuckerberg. However, there is, every indication that there's going to be a lot of changes, occurring with, certain aspects of adjudication. And we can expect that one who is, seeking changes to their H-1B might be subject to greater scrutiny. So that's why it's really important to think about all your options so that we could put you in a better place and that you're not going to be at the mercy of your employer. Because I think beyond the immigration changes over the next 4 years, there's going to be a massive amount of technology changes, of changes in, robotics and, replacing, positions, particularly in coding and these kinds of areas. So it's really important to sort of, secure your position and consolidate the gains that you have and seek out all the help that you can get. So I thank you for tuning in. We'll keep updating you all as, events evolve, and are here to answer all your questions and help guide you to a wonderful and bright future.